this presentation is about my forthcoming book. As I have been working on Chinese multinationals in the U.S. and how they adapt to the U.S. system uh, for quite some time. And in 2018, I published a book titled "The Clash of Capitalisms." That book was really mainly about the compliance by Chinese multinationals with U.S. laws and regulations. And this book, Negotiating Legality, is about how Chinese multinationals engage U.S. lawyers, how they develop internal legal capacity, how they negotiate the legal risks and opportunities in the U.S. So the focus is different, but and it incorporates more years of survey data and interviews. So I'll get to the details of the research methodology in a moment. But the book is coming out in May 2024 in basically 2 or 3 months. Yeah, that is by Cambridge University Press. So without further ado, let me get to the substance of the book. So here is the list of the chapters in the book. Um, so I start with the overview of Chinese companies in the U.S. legal system. And I look at the in-house legal capacity developed by these Chinese firms. And as you'll see, some of them have established full-time legal management positions. Others have not, and also the personal attributes of the in-house legal managers also vary across different firms. And this book explains why that's the case. Now I talk about how um, even Chinese companies with internal legal capacity will have to rely on outside lawyers to navigate the U.S. legal system because its complexity and its unique features. So there's a chapter in the book explore how Chinese multinationals engage with U.S. lawyers, right? To an extent, they rely on lawyers in business transactions, in dispute resolution, how they select lawyers, and their legal budgets, right? The idea is that if they have enormous amount of revenue allocation for legal expenses, then they will have more leverage over U.S. lawyers, right? Their preferences will be more effectively reflected in how U.S. lawyers provide legal services. In other words, the Chinese multinational in that kind of circumstances will have more bargaining power, and they will therefore have more impact on the U.S. legal profession. And then chapter 4 is about U.S. litigation by Chinese companies. I start by looking at their preferences about litigation in China, right? To what extent the Chinese companies are reluctant to litigate in the U.S. because of the influence from their home country normative context. And to extent they have adapted to the U.S. Legal system and make rational decisions when it comes to litigating dispute in the U.S. This chapter is based on survey data, so there are some issues with quality of the data. So chapter 5 will continue on this topic, but it relies on objective data. I collected cases from Bloomberg Law database and look at how Chinese companies litigate in U.S. federal courts, right? How often they are sued in the courts, how often they initiate lawsuits against other parties in U.S. federal courts. So chapter five is another take, another um, angle, right, through which I explore Chinese companies' litigation behavior in the U.S. And chapter six is about a specific but also very important topic, that is Chinese companies' legal strategies against U.S. government mistreatment. A good example would be Huawei, right? Uh, because for reasons I'm sure you all know, uh, Huawei is treated really with great hostility in the U.S. by U.S. government agencies. And so, and they don't have, Huawei doesn't really have alternative remedial measures available, so they can only resort to legal remedy. So you see Huawei actually litigate many cases against the U.S. government in U.S. Courts. So this chapter is really about that, that type of cases. Um, when Chinese companies are mistreated in the U.S., how likely they will go to court to protect their own interests. And then the book concludes with some discussion about contributions of this book and questions for future research. All right, so a bit of background. This is the trajectory of Chinese investments, both inbound and outbound. As you can see, over time, you can see a clear upward trajectory. But in the past decade, um, FDI actually outbound FDI peaked around 2016-17, and then has basically plateaued because of both domestic investment policies and also because of global geopolitical risks. All right. So you can see that Chinese FDI in the U.S. parallels the previous chart, right? Chinese FDI in the U.S. basically uh, increased significantly around 2016 and 17, and then plateaued, which is consistent with the overall amount of Chinese outbound FDI. I would like to start the substantive discussion with an example, right? TikTok. So TikTok's litigation experience in the U.S. It started 2017, right? The business started in 2017, and there was only one lawsuit. Um, in 2018, there was no lawsuit at all, and then 19, there were only four, but still some increase, right, compared to the previous 2 years. In 2020, then you can see the explosive growth of lawsuits involving TikTok. And if you break all the cases down by the role of TikTok, then TikTok, there were only four lawsuits where TikTok was a plaintiff, and all the for all of the other cases, TikTok were defendants, and and among those cases where it acted as plaintiff, three cases were filed against the U.S. government. So this is TikTok is not unique in that sense. So if you look at several other prominent Chinese companies in the U.S., you see a similar pattern, right? Very often, the number of lawsuits start at a low level and then it steadily increased and then peaked at a certain point. Um, but for some companies, uh, there was a surge of cases in recently. And if you look at, for example, Huawei is such a case. Uh, Lawsuits for Huawei, the number of lawsuits for Huawei peaked around 2015. Then there was some decline, but then recently it increased again because Huawei filed a number of cases against the U.S. government agencies. All right. So um, now that's is this research new? Well, a little bit discussion about literature review, right? As you will see, so far, the scholarship on this topic is very limited and very much marginally related to the topic of this book. So, while there's the literature on comparative institutional analysis, some scholars uh, look at multinationals and how multinationals in the U.S. and how they cope with the complex U.S. Legal system. And the conclusion basically is rather straightforward that the U.S. Um, legal system, so-called adversarial legal system, is consists of a number of institutions, interrelated institutions, and um, uh, impose very heavy cost on foreign businesses in the U.S. All these companies, based on these case studies, appear to straddle appear to feel to be challenged, right, by the complexity of the U.S. system. But that's basically what this literature is about, right? Case studies of multinationals, um, which are well based in developed countries, and um, so they are not really the findings very insightful, but not really helpful for understanding developing country multinationals and how they navigate U.S. law, legal risks, and opportunities. And there's a literature on liability of foreigners. Basically, the scholar in this area find that foreign companies are sued more often in U.S. courts for lack of familiarity with the U.S. legal system. Again, the literature focuses on developed countries and says little about emerging market multinationals. And also, uh, the research is relatively narrow, right? Just look at the number of lawsuits these multinationals litigate, right? That's it. It fails to address all the other related questions, such as how they engage with U.S. lawyers, right? And then there's a literature about xenophobia in U.S. courts, uh, but the focus of this literature is whether or not U.S. courts are biased against foreign parties, including foreign multinational corporations. Again, this is a very interesting research topic and important and relevant, but the literature just revolves around that topic and doesn't really touch on all the other related topics to be explored in this book. And last, there's a literature on U.S. jurisdiction and forum shopping, right? This literature is about how foreign parties try to access U.S. courts in order to take advantage of the adversarial system with jury trials for civil cases. So foreign parties, especially tort victims, very often are lured to U.S. courts to uh, they will file cases in U.S. courts against multinational corporations for claims of human rights violation or other types of international law violation. And so this literature is really about the limit, the extent of U.S. jurisdiction and foreign shopping. So, so it's not very insightful and interesting, but not that relevant to the topics of this book. All right. So let me uh, all the chapters in this book, uh, each of the chapter touches on a specific topic, even though they are all related and crucial to understanding how Chinese firms negotiate U.S. legal risks opportunities. They are traditionally they belong to different disciplines. So how do I um, combine them? How do I analyze all of these different topics um, in the under one unified analytical framework? So this is the framework I propose, right? Is I argue that to understand how Chinese multinationals negotiate U.S. legal risks opportunities, you need to look at the dual institutional context in which they operate. Right. First of all, they need to adapt. They need to. They are under the influence of the host state institutional pressure. Right. They have to comply with U.S. law. Right. They are under pressure to adapt it to U.S. law norms, social norms. But on the other hand, these companies also are subject to the pressure of Chinese institutions, both formal and informal. So constantly, um, these multinationals feel the tensions between the two institutional contexts. They have to address these tensions, and how they do so should modify or should shape their um, preferences and interests. Okay, so that's the dual institutional framework I apply throughout the rest of this book. Methodology, right? So I use mixed methods for researching these topics. So primarily, I rely on survey data. I've been collaborating with China General Chamber of Commerce, and we send out surveys from year 2014 to 2022. Some of the questions are relevant to my research, and so I was able to collect quite comprehensive survey data about Chinese multinationals and the U.S. legal system. But with all research that use survey data, there's always the concern about some biases, right? Missing data bias or uh, selection bias, whatnot. So, and also the questions vary across different years. Some surveys include more questions relevant to this book, others less. So, so in order to uh, remedy that or mitigate the problems with survey data, I also conducted more than 170 interviews with knowledgeable individuals. Um, uh, and these are the backgrounds for the interviewees. As you can see, they come from different walks of life, and they were able to provide me with more first-handed information, insights that help me understand how we interpret um, the findings from the statistical analysis. And then also include judicial archives in the analysis to make sure that I fully understand what's going on in course. All right, and so that's the setup for this book. Um, Chapter 2 is about in-house legal capacity of Chinese companies in the U.S. So for this, there's actually literature, but there's in the past few decades we have observed a in-house counsel movement in the U.S. where corporations internalize legal service production um, instead of relying 100% on outside counsel. They set up legal departments in their government structure, um, and the in-house counsel play a very important, increasingly important role um, in purchasing legal services and in advising their corporate employers, right? So there's a literature about that movement, and but I don't want to go to the details. Suffice it to say that um, the literature has neglected uh, international multinational corporations, let alone multinational corporations from developing countries. All right, so they are not very helpful, right? And there's also literature in international human rights management, human resource management, but again, not they're insightful, but the findings are not helpful for this book. Applying the dual institutional framework approach, I look at both the host country institutional context and the home country institutional context. The former has been thoroughly researched, so I didn't spend much time on that. I focus on the home state institutional context. And the book gave analytical review of how um, the Chinese in-house legal capacity, how Chinese in-house uh, 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 developed over time. And you can see a lot of top-down pressure for Chinese companies, especially state-owned companies, to develop in-house legal capacity. And that's unique, right? You don't see that kind of top-down pressure in other countries. Of course, there's some modified form of such top-down pressure, right? In the US, you have the federal sentencing guideline that put some pressure on corporations to internalize legal service production, but there's just the pressure is indirect, unlike in China, where SASAC specifically instruct SOEs to expand in-house legal capacity. In addition to that, uh, Chinese Chinese companies also, especially privately owned Chinese companies, also are investing in in-house legal capacity, and the reason is that, well, it's getting costly, more and more costly to litigate. So it just makes business sense to invest in a dispute prevention or to avoid escalation of uh, disputes, or to scrutinize contracts to so that legal disputes are less likely to occur down the road. So for various reasons, right, private POEs in China also have um, uh, invested in internal legal capacity growth. So you see both top down and bottom up pressure on Chinese companies to pay more attention to internal legal service production. How about Chinese companies in the U.S.? Right. So this is the data I found this through survey, 2019 survey. So the majority of Chinese companies still do not have full-time legal managers in the U.S. And based on interviews, these companies uh, basically don't have enough legal issues to handle internally. So they have occasional lawsuits, and their transactions tend to be standardized. So there's no need for hiring a full-time in-house legal manager. and it's more cost effective to outsource such work to U.S. lawyers. So you see, why that's the reason the majority of Chinese companies in the U.S. do not have full-time uh, legal managers. But for those that do, you see quite interesting variations, right? Um, of course, among them, the majority have uh, local lawyers, right? They hire local lawyers as U.S. legal managers, but some of them expatriate uh, U.S. managers, or they hire lay person to be in-house legal managers. So that's puzzling, right? Because law is local, law is very complex. It requires professional expertise. So how what's the justification for expatriating U.S. legal managers? What's the reason for hiring a non-professional as the U.S. legal manager, right? So based on an interview, right? Based on interview and data analysis, I find that state-owned enterprises are more likely to uh, to expatriate U.S. legal managers, to send someone from the headquarters to the U.S. to manage U.S. legal matters. And why, right? So the interviews show that they don't trust local hairs, right? Because they're worried that local hairs will become whistleblowers, right? Uh, it's almost certain that um, if you dig deep enough, right, you'll find probably some illegal issues. And um, for the managers, they want the in-house counsel to help them solve the problems, not to report to the U.S. government, right? So they need trust, and you don't get that trust from a local recruit. So you tend to send someone you know for years from the headquarters to the U.S. to manage U.S. Legal matters. And also, there's multitasking, right? Chinese SOEs tend to multitask, right? Profit maximization is just one concern. Very often, it's not the important consideration. There are other um, uh, issues, right? Other concerns for SOEs, and such considerations tend to be beyond local recruits, right? They just don't get it. Um, so in order to exercise control, right, it makes sense to for Chinese SOEs to expatriate someone from the headquarters to the US to manage local legal matters. And another variable that's important is U.S. market importance. This finding is consistent with the existing literature. The idea is that if the Chinese multinational consider the U.S. market to be very important, it will more likely to exert tight control, and for that, it will send someone from the headquarters. So this is really the control incentive that's pushing Chinese multinationals to expatriate U.S. legal managers. And then my research finds some other variables that are associated with recruiting local legal managers. And this finding is quite intuitive, so in the interest of time, I will just skip the detailed discussion. Um, how about hiring a non-professional as U.S. legal manager? Well, here, um, again, I find that state ownership is a significant variable. Basically, state-owned enterprises are more likely to hire a non-professional to manage their U.S. legal matters. Well, why? Well, again, lack of trust is an important explanation. And also because of the top-down pressure, right? SOEs tend to uh, over well, create positions in order to signal their support of SASAC rules, SASAC instructions. They don't really have the need to have an in-house counsel. They don't have the service need. They just do it because in response to the top-down pressure. And because without the service need, they don't need a professional lawyer to handle the issues. It's really for window dressing purposes. So they need a layperson will do, right? It will be sufficient. That's another reason. And also, again, there are some other variables that are associated with hiring local lawyers as U.S. managers. And again, because of time limit, I'll not get into the details. So for Chinese companies with in-house, even for Chinese companies with in-house counsel, there's no way they can handle all the legal issues internally, right? All the companies have to rely on outside lawyers, right? But how do they do it, right? That the answer to that question closely related to how they negotiate U.S. legal risks and opportunities. So let's look at uh, their interactions with lawyers, right? So let's before that, I want to highlight their litigation preferences, right? And I want to show that the data suggests Chinese multinationals actually their preferences reflect to a certain extent the home state normative influence. So if you look at the chart here, right, majority of them, when they were asked the question, do you want to set? So are they more compared to what you do in China? Are you more likely to settle or litigate disputes in the U.S.? The vast majority of them would actually are more inclined to settle disputes in the U.S. Right? And why is that? Right. Well, I'll get to the why question in a moment. But you see, only 16%, about 16% of the Chinese managers appear to be more inclined to litigate in the U.S. Right. So that's interesting. Why? Because you would think that with independent judiciary, powerful in judiciary in the U.S., the Chinese companies should be more inclined to litigate, right? But that's not the case. Well, it appears that most of them will take into consideration a higher cost, higher litigation cost in the U.S. So they prefer to settle in the U.S. to avoid the cost. But also, if you look at uh, uh, the bars to the right of the middle bars, so litigation is bad for reputation, right? That's the reason given by some of the managers for the reluctance to litigate, right? So that's a clear reflection of home state normative influence. They associate litigation with reputation damage, right, within the Chinese cultural context. So they carry that they carry that norm to the U.S. Um, uh, uh, so that's reflected, the inertia reflected in this data. And lawyers' role, right? Um, Here again, you see both adaptation and some inertia, right? 86% would immediately seek legal advice when dispute occurs. That's what you would expect in the US, right, from a US company. But still, almost 14% would seek legal advice only after settlement has failed, right? So that reflects more this home state norms, right? To to postpone the use of lawyer legal service until they have no other choices. And how do they select lawyers? What do they consider important in the selection of U.S. lawyers? Well, here's the list. Well, in the interest of time, uh, I will skip this detailed discussion. And and how often do they sue? Do they litigate in the U.S.? Well, this is based on objective federal archival data, and so this is the distribution of Chinese companies by number of federal lawsuits. Most of the Chinese forums companies don't litigate that much in the U.S. So that's why the distribution is tilted. But some of them do. So what explains the significant intercompany variations? Well, here I did the book did include some statistical analysis, and interestingly, state-owned enterprises appear to be sued more often in federal courts. Right? So it's highly significant. State ownership is highly significant. Why is that? Right? My interviews suggest that managers at SOEs, because of the multi-agency and multitasking problems with SOEs, they handle disputes in a suboptimal way, right? Their incentive is distorted, so they don't settle when they can. They don't avoid dispute escalation when they can. So in the end, we have Chinese SOEs sued more frequently in U.S. federal courts, when you have all other variables held constant. And then investment duration is significant, which is highly intuitive, because the longer you operate in the U.S., the more likely you have litigate some cases in U.S. courts. And revenue is significant for both the plaintiff test and the defendant test, which is intuitive, right? Larger Chinese companies more likely to sue because they are capable of doing that. Also, they have more legal issues. Some of the issues may escalate into lawsuits, and they are bigger targets. So for U.S. plaintiffs, they are deep pockets that attract lawsuits. And so market importance is also important, and sectoral regulation is important, significant, associated with the number of lawsuits as defendants for Chinese companies. So, federal courts, of course, of limited jurisdictions. So if you can litigate if you have breach of federal law, right? So that's why you see positive correlation between sectoral regulation and Chinese companies' number of lawsuits they defend in federal courts. And in-house counsel is also positively associated with the number of lawsuits as a defendant, which is interesting because it suggests that the in-house legal capacity is developed over time as a defense mechanism. If they're sued, if Chinese companies are sued, they're more likely to try to internalize legal service production to prevent future lawsuits. So in the interest of time, I will skip the discussion about contributions, but I want to just say a few words about the last one, U.S.-China relations. So increasingly, U.S.-China relations has contain a legal aspect, right? Because of the political rivalry, a lot of transnational actors have their interests infringed upon by by both governments, and their only remedy these days is litigation. So you see more and more cases coming out of U.S. courts, especially um, filed by Chinese companies against the U.S. government regulatory agencies. So law has become an increasingly important part of U.S.-China relations, and I hope this book narrows some of the knowledge gaps and also pose questions for future research. Thank you very much, and that's the end of my presentation.
Especially for people who haven't studied in the US law is complex on a number of ways. And your case studies, I think, really get at this. I think there's this old apocryphal story that Japanese companies in the 80s would say that the US legal system was a non-tariff trade barrier once they actually arrived in the US, because the local and federal complexity of US regulation, especially in private law, is all over the place, right? So working in Ohio versus Florida versus California has significant differences. But one of the other things that happens is that there's been this transnationalization of expertise that sort of overlays these types of dynamics in between systems. So many of the people that you mentioned are in some ways originally Chinese or originally American and probably from other places as well, right? But they've developed a particular expertise in managing exactly this type of interaction, right? Which is something that didn't exist before. And so I think the in-house counsel example, which I'm glad you picked that chapter of all of them, is sort of exemplifies this, because in-house counsel has not been static during this period of time, as you mentioned, in the US, and it hasn't been static in China domestically. So if you're going to look at something like this, right, you have to know what's happening in China and you have to know what's happening in the US at the same time. And I think, if you actually look at the book, he does go through all these different variables in each one of these chapters, looking at sort of what really matters. So you really disaggregate the idea that there is sort of like a Chinese multinational, which I think is quite important. It's not just state-owned versus private, which you go, but you look at different sectors. What type of business are they involved in? How does that lead to different contexts? What type of leadership structure do they have? So by disaggregating this and looking at all these different factors, you're able to tell like a more compelling comparative story. Now, in part because these issues are on my mind quite a bit, the one way that I sort of wanted to sort of push you is a lot of this sort of is posed in a traditional way of like, there's significant differences. Like you use the sort of language all the time of like, there's significant institutional gaps or large. And I wonder if like, if we took the counterfactual of like, let's imagine a Chinese SOE in 1968 trying to move to the US to do business. I think there we would expect that it's like vastly different. So one of the things as I was reading through this, there was actually much less friction than you would expect, especially because we're not talking about chapter 6, in this era of decoupling, right? There's this concept that like American and Chinese societies in some deep and abiding way have absolutely different ways of doing all sorts of different things. But if that was true, you wouldn't have the story that you're telling, right? You would have a very different type of story, right? And so one of the interesting things is the commonalities, right? So American law firms complain about Chinese businesses, and then you turn around and it's like, well, these are the same complaints they have about American businesses, right? The sort of unlimited billable hours thing is something that comes up all the time. And so it's interesting, even though it's like hard to sort of play out, that some of these things people have assumed US baselines, right, about litigation, right, or even about like a credentialism in hiring, that themselves often are empirically taken for granted. So one of the interesting things, sort of like future research, like how really different, right? Every time you do this survey, the truth is empirical studies of the legal profession, like Julia has done for Chinese companies, is relatively underdeveloped and new in the US, right? There was the American Bound Foundation just did this big after JD program. And the truth is, for many sort of decades, a lot of things about how American sort of legal professions and professionals operated was taken for granted. And I think one of the things you also do is you show like you have this variable of culture, right? And I don't like quantitative comparative law, generally speaking, right? And your variable is either they have cultural distance or they're not. It's like a 1-0 coding, right? But it's interesting when culture does and does not play a role here. And I think the interesting example you talk about here is that when things are serious, right, when the US government sues a company, all of a sudden culture falls out as an explanatory variable. And that's a very particular way, like the stakes are high, so everyone has to be rational and not think culturally, right? It's sort of like an implicit thing there. And I think you can see that as being, again, a general comparative dynamic about when does cultural sort of difference really matter in that context. And even when you talk about litigation, this like goes back to like Japanese, like studies of Japanese dispute resolution in the 80s. Again, this sort of culturalist framework to explain everything. sounds good until you actually look at the institutional framework, right? And you're able to sort of get down and sort of look at, when it comes to dispute resolution, yes, there might be some impact, right, of the home state sort of normative framework, but it's not overbearing, right? It's not like the only thing by any context. And so I think the one thing that sort of really sort of struck me is when because it's something I've looked at. So if we look at the operation of something like an employment or labor law, which I look at, and which you touched on here most specifically in the Fujao context, is you mentioned sort of things that I hear all the time. And you mentioned the most common one, which is anti-discrimination law, asking women when you're hiring them whether or not they're going to have children, right? Very, very common in China, big no-no in the US, right? But what you don't follow up in is like, did she sue the company, right? Did she get an anti-discrimination claim? Because the difference between the formal law, right, and the law on the ground is, involved in similar types of dynamics. But you mentioned the American Factory movie. If you're not familiar, this is the American Factory movie was made about the glass magnate who moved into this formerly unionized factory in Ohio, right? One of the interesting things, you mentioned that they have all this employment and labor litigation, but just like American companies, almost nothing happens when they violate the law. So the owner is actually on tape, right, saying, I'm going to fire all the union organizers who work at my company. Now, that's a blatant violation, like it's the most egregious theoretical violation, right, of collective bargaining in the US, but very little happens because very little happens, right, in the US when US companies do that. So the actual friction of bringing in these different managers, and you do mention that they replace, right, someone who has bicultural expertise in that context, it's actually not that hard to adapt, right? Now, again, that's a relative judgment, right? It's not that hard to adapt. But one of the interesting things also is like you investigated people's backgrounds by looking at their LinkedIn profiles, I noticed. Well, all these people have LinkedIn profiles, right? They are part of something, right, that isn't purely driven, right, by their sort of local dynamics in that context. So the other thing is, so if I'm going to say, like, you look at all these big gaps, and I'm like, actually, the thing that strikes me is how similar they are. We start thinking about what would be the relative comparator. So, and again, this is unfair because the book already has a wealth of information, but thinking about like, well, what about Japanese companies in the 1980s? All of these stories played out in this. There's a very famous movie with Danny DeVito plays in, again, where a Japanese company buys an American formerly unionized company and all the different things that happen in that context. And you do mention like once like Korea, right? Korea is a similar context, but I wonder then if we could sort of, if we were going to sort of say, is it closer or is it far away? Think about like, well, there's been companies that have been in the US for a very long time. Like the time frame we're talking about historically is short. So like there's been German companies that have been in the US for 100 years, right? Or French companies. And you use sort of this, you use Canada repeatedly as like, everything would be easy for a Canadian company, right, to move from the US, from Canada to the US. And I sort of wondered if that was true, right? I mean, if they're from, if they're from Quebec, it might be a little bit more difficult for them to do that. And then you mentioned like India and Brazil, like India and Brazil are democracies. Well, it's just like, I mean, I know a little bit about Brazilian US dynamics, and Brazil's a civil law country, and India has lots of sort of, there's so many things about those places where it might actually be harder for them, right, to engage with the US market than China, right? In part because there has been so much economic integration. So in that sense, I was sort of really fascinated about like, how can we sort of really look at this as something that is like friction generating and exceptional, or is this actually an example of something that's very successful, in part because the gaps between a 1964 Chinese SOE and a 2024 Chinese SOE compared to the US legal and institutional regulatory framework is actually crazily small, right, in that way. So I think this is also interesting because I think the last thing I'll say is in this sort of decoupling time, when people talk about the US and China being so different, one of the things that you highlight is that this is coercive state behavior, right? That these companies are, it's like the US state says, I don't like you being here, I'm going to do something for a variety of reasons. And we see this like the internal circulation on the Chinese side as well. It's not private companies going like, oh, this is like too much, like the cultural difference and how we deal with like employees, right? Or how we deal with stockholders if we're private is so vast, right? That we're just going to take off, right? Now, again, maybe there are sort of like false positives because we don't see all the companies that sort of leave because you study ones that have like a longer term. But I think in the end, that really begs this question of like, if it wasn't for coercive state action, is there actually enough sort of friction in these ways that China would ever have anything but increasing integration with the US economy, and much more so than a variety of other countries who we might just instinctively, but maybe falsely assume would have an easier time in the US. So I think especially as we see the next couple sort of like decades, fall out, I think that's one of the interesting things. If we have a time with your sort of Biden original optimism where the US administration pulls back, or maybe there's a different administration in China, would it just, all of these sort of issues would go away and all of these, sort of frictions would increasingly narrow over time.
Would you like to quickly respond?
Yeah, well, thank you very much. These are very great comments and suggestions for decades of future research. So thank you. Yeah, I totally agree. I mean, over time, right? An issue that future research will probably want to address will be this cross-border influence of the two institutional contacts, right? And also over time, you see the changes. There's a learning effect, right? There's a learning effect. I just totally agree. I mean, those, for this project, sometimes I have to take a snapshot and do what I have to do with the data. But so yeah, great. And also, I agree that the culture, right? In order to measure, it is so difficult to measure culture. So here I really just use a very subjective measure. And what I show is not that culture dominates. What I show is there may be some significant normative effects here. So that's all I present in this book. And for most of the questions or issues explored here, the managers seem to engage in cost-benefit analysis, right? When it comes to hiring lawyers, when it comes to developing in-house counsel, when it comes to escalating disputes to litigation, they still do this cold cost-benefit analysis, but there seem to be effect of culture, home state culture. So that's what I present. I think is interesting, but definitely in the future, there should be more study that further unpack the concept of culture. And yeah, and the last chapter talk about Brazilian companies, Indian company. It's really just I try to open the floor to for further discussion and investigation. So yeah, so those are very good comments, and thank you. They give me ideas for future research. Definitely. Thank you.
Wonderful. So we have a few minutes left, and I am now opening up the floor for Q&A. And when you think about your question, let me ask my first question. So once upon a time, I was one of those lawyers advising Chinese state-owned firms when they venture overseas. And in fact, I was an associate working in the London office of the British law firm. And one of my biggest clients is a Chinese state-owned firm, state-owned oil and gas company, which is making a joint venture investment in Europe. And that happened during the boom after the financial crisis in 2008, where a lot of the Chinese firms venture overseas because they saw the assets in the US and China are very, very cheap at that point. So, and that experience connect with what you describe in your study, and it's definitely compatible with what I observe, because my client precisely is somebody who is not US trained and is an expat to Europe. But different from your study, which I think, I don't know, I haven't read the book yet, is that, they leverage, right? I mean, despite the fact that their own people don't have the knowledge, they are very good in outsourcing their work to outside counsels. That's why they hire and approach us. And in fact, almost all the leading, these are the highly sought after clients by US and Chinese top, top European and American law firms. And so do I need to be worried that these Chinese legal firms don't have, very competent people inside the team, but they're good at outsourcing the work to external lawyers? That's my first question. And the second question is regard to, the type of litigation that we observe for different types of companies. I mean, the stable firms that I work with, they don't have much litigation. And that also has to do with the type of firms, the type of business they operate in, right? I mean, whereas maybe for, private firms venturing to Europe or US, they may be more susceptible to litigations because they do different business. And the stable firms have very different risk appetite than the private firms. So some of the results that we observe here might be endogenous to the type of business that they invest in, their own risk profile, the management style, etc.
Great. Very good questions. So, yeah, SOEs are supposed to be, I expect SOEs to be more inclined to outsource legal work. Why? Because they want to mitigate the risk. They outsource the work to outside lawyers. If something goes wrong, you can blame outside lawyers. That's bureaucratic risk aversion strategy. So definitely, I would expect that. Should we be worried? It depends on the what we are talking about, right? Lawyers, of course, welcome this, right? But if things goes wrong, of course, the lawyers will bear the blame for sure. And types of business, for some of the tasks, I control the sector, but I totally agree, right? As I mentioned in the book, there's a lot of personal attributes of the survey subject, and that may influence the result of the tests. So that's something I'd assume to be to be independent to the dependent variables of my interest. But definitely, I mean, in the future, actually, for some of the tests, I did run robustness tests. I control the tenure of the survey subjects, but for those tests, it seemed that the variable that doesn't matter. But I totally agree. I would assume that the manager's background, right, where they got their credentials, right, their specific training. I think those factors shouldn't matter, but that's something to be explored in future research. Yeah, good. Thank you.
Any other questions from the audience? Yes.
Thank you, Professor Lee, for this very informative and interesting research. So a very quick question. I wonder, and since your research is spanned over on many years, right, on almost a decade on this topic, and I wonder if you've seen any, say, the impact of changing institutional environment back in China on the legal compliance of Chinese companies, especially SOEs overseas. For instance, starting from around 2016, 2017, the Chinese government has launched a sweeping campaign on compliance, right? 合规 reform among SOEs, especially centrally controlled SOEs. And I wonder in your research if you've noticed any change that was resulting from that sort of change in the regulatory environment in China. Thanks.
Yeah, very good question. So that's not in, or my earlier book was on compliance, but the data was limited to 2017. So what you mentioned was happened thereafter. So, and this book is about more about litigation, dispute resolution. So yeah, that's another good question to be explored in future research, I guess. But this relates to Jeb point, right? Definitely in the future, you want to see how changes over time, temporal changes in both the domestic and the host state institutional context may implicate the coping strategies of multinationals. Yeah, definitely a good question to explore in the future. Yeah.
Okay, we have one more question. Yeah. Would you like to introduce yourself?
Hi, thanks, Professor Lee, for your informative presentation. I was looking at the tape, like you're trying to show us, like the companies were sued, Chinese companies were sued in the US courts. And I was thinking about what was exactly the reason, like either it's state-owned enterprises or the private actors. I was thinking about, was that because of something we call culture difference, like those companies haven't got a sense to build a strong governance and haven't realized the importance of a strong in-house legal capacity? Or do you think it's more because that the business sectors, those highly profitable business sectors they're in, are highly regulated by the U.S. government? I mean, they're the target of the U.S. Government regulation. So I was talking about those sanctions, like the executive orders by the U.S. president. I noticed that lots of the industries were like semiconductor manufacturer, chips, or telecom. So I was thinking about what was exactly the reason, or like which viewpoint are you leaning towards?
Right. Good question. So I only show the chart very briefly. So the sector variables, the variable of sectoral regulation is significant, which makes perfect sense because federal courts are courts of limited subject matter jurisdiction. Very often you need, unless it's a diversity case, right? I guess so. Federal courts, of course, they can only adjudicate certain cases. Unless state courts, they can adjudicate any cases. Federal courts can only adjudicate cases that implicate federal law or diversity, where the case need to be between two parties of different states, and then the subject that was at stake has to pass certain threshold. So most cases are based on federal law in order to get into federal courts in the US. So that's why the sectoral regulation, and that's the variable, is highly significant. It's intuitive. So I control that variable. I still find state-owned enterprises are more likely to be defendants in U.S. court. Your question is, why is that? So my interview suggests, shed light on this correlation, right? Is that state-owned enterprises make litigation decisions suboptimally in the sense that, well, because of agency issues, right? They not only they very often don't, they're less efficient in preventing dispute escalation, right? So because of the agency problem, because of information asymmetry between headquarters and the lower the subunits. So for agency issues, for transaction cost issues, it's just they're not very effective in preventing disputes. They're not very effective in accumulating institutional memory to prevent dispute escalation. They're not very effective in settling lawsuits outside courts. So those are my explanations for the interval. Yeah, thank you.
Okay, great. So we are running out of time. So we have to wrap up now. And thank you guys for coming. Thank you, Professor Lee. And thank you, Jack, for participating. And I will see you guys next time.
Thank you very much.
Yeah.